Alrighty, so of course this is the mortgage take back class um, on how to take back everything that belonged to us. Now, mortgage is just not your house or your land. You are a walking mortgage. Because if you guys have been reading the prospectus, you'll see that everybody says that they are selling what? Mortgage-backed securities. So how's your light bill a mortgage? It's because you the mortgage. Because when you look up the definition and break the word mortgage down, you have more, which stands for mortician, because we're all supposed to be dead, right? So look at it, mortgage, mortician, right? And then of course, gauge is the pledge. So you're pledging a dead entity. That's why everybody's prospectus, regardless to what it is that you have acquired, will say that you are a mortgage. But you are doing in a mortgage is way deeper than a SES. Way deeper. A SES ain't gonna do you no good without all of the additional steps that need to be done and the filings that you have to do. If you guys have actually took the time to read your mortgage, your deed of trust, you will see that you basically told them that they can have it, right? It says it. Like if you read it, it almost looks like you wrote it. Your signature, the only signature on there too. So it does look like you wrote it, right? So due to the fact that it looks like you wrote it, you can change it. It looks like you um, authorized them to be trustee, but based off of the Trust Indenture Act of 1939, we do have to have a middleman to get to the window. So they are the middleman, right? So you can't X them out because you need these brokers, these security transfer agents, but you need to know how to properly deal with them in the proper capacity where you're winning and they're winning and both are winning because you're doing a barter service that turns into a gift because of how the paperwork is written. But you can definitely change the deed of trust. You can assign your own trustee, which I would say let it be your own trust. Because as I stated, it looks like you wrote it. In order for a mortgage to be considered a full mortgage, the mortgage has to be registered and titled properly. If there's a break in title anywhere, then that calls for who owns it. That calls for can they really foreclose on you? Because they never perfected the title itself. There's not been one audit report that I've seen that it was actually perfected because they never turned the paperwork in because they can't perfect it because they sold it to they sold the contract. There's someone else that's over trustee, which is where the title company comes in. Okay.
Y'all
But then
to
again,
burn today.
you told them this. You told them they can do it. Everybody screams and talks about TILA. Oh, they violated the Truth in Lending Act. Did they? But I can tell you that the Truth in Lending Act is the only law that is needed when you're doing a consumer credit contract. Everything else from the car, none of that falls up under TILA. TILA is strictly for mortgage. There is somewhere within your mortgage documents where it told you that you had 3 days to rescind the contract. But let us know if you're going to keep the property. It's there. Now, if it's not there, now you can get them on false and misleading contract, fraud, deception, or whatever. But it's there. It may not just be worded in words that you can understand, but it's definitely there that you had 3 days to rescind the contract. And in rescinding that contract, they have 21 days to come and try to redeem the property from you. But they also have to give you back everything you gave them. That's not just down payment. That's not just closing costs. They have to now give you back the security. Do y'all really think they're gonna give you the security back?
Nope.
Honestly, not when they getting 400 million at the window. Because you have to remember that if you do a 3-day recession, they have to give you back everything. That's including the security, the original issue discount, and etc. No, but the clause is definitely in there. You just failed to read it because they made it seem like it was the American dream to own a house when you are the mortgage itself. So this will be, as I say, a two-part class. Today we will go over the mortgage document itself. There are some things in there that you may not understood exactly because when you go to changing things within that deed of trust, you have to know what's there in order for you to be able to change it. You have to understand what it means and why you have to change certain language and then go refile your deed of trust. Why it's important to put a list pendants and a quiet title on the property. Because with the quiet title and the list pendants, now this bank who claims that they have ownership of your house now have to legally prove that they have perfected the title, which they will never be able to prove, right? Um, so those are some of the steps that have to be taken when you're in the process of doing a redemption. So Caleb is going to go over the contract was within itself. That is what will happen today. And the next, like I said, the next class is Sunday. So hopefully tomorrow you'll pull your own mortgage out and start comparing it. And based off of the things that you learned today. So on Sunday, we'll go over what's needed and where you got to go file, who you got to talk to, what it should look like, right? Have anybody ever heard of the RESPA, RESPA? Yeah.
She going over everything.
Like, yeah. And the RESPA, I have a RESPA document I did. I think it's like 17 pages because those are all the questions that I can ask, right?
Hmm.
Because just filing a 1099A or 1099C is not going to be sufficient when you're dealing with the mortgage. Okay. So today Caleb is gonna go over the mortgage contract within itself and we'll go from there. So hold on, Caleb. I'm gonna pull it up, whatever I did with it.
Oh yeah, I'm excited for this one. Y'all are about to get a knowledge bomb for sure.
You
Um,
wanted to start with the deed of trust, right?
mhm.
Okay.
We're gonna start with the deed. So while that's getting pulled up, I want y'all to write this down. Okay. This is from the Security Exchange Act of 1934, obviously. This is on page 24 of the document that I'm looking at, section 3, subsection 41. And that is the term mortgage related security. Now, it tells you the term mortgage related security means a security that meets the standards of creditworthiness as established by the commission and either represents ownership of one or more promissory notes or certificates of interest or participation in such notes, including any rights designed to assure servicing of such notes, certificates, or participations of amounts of payments, amounts payable under such notes, certificates, and participations. And it will tell you further on, I'm still reading the same definition, that such notes are directly secured by a first lien on a single parcel of real estate. So that's one. There is two different, and there's more under that definition. Um, from the Securities Exchange Act of 1934 is where I'm reading from. Hold on, we might be pulling it up. One second. Okay, so yeah, we're getting that pulled up for you. Now, the second part is it was originated by a savings and loan association, savings bank, commercial bank, credit union, insurance company, or other similar institution which is examined by federal or state authority. And then B is it is secured by one or more promissory notes or certificates of interest or participations in such notes with or without recourse to the issuer thereof by its terms provides for payments of principal in relation to payments of reasonable projections of payments on notes meeting the requirements of subparagraphs A, number I, and 2. Because it's when you read it, you'll understand, because you know how they'll have a letter that's in the parentheses and then they'll have two more. So yeah. But the other last part of that definition that I want you to focus on is this. For the purpose of this paragraph, the term promissory note, when used in connection with the manufactured home, shall also include a loan, advance, or credit sale as evidenced by a retail installment sales contract or other instrument. Because this definition from the Securities Exchange Act tells us three different things that we need to know about what we are going to consider mortgage-backed securities. The first is that you must have ownership of the note or evidence of interest in participation. So when I was, and I'm going to get into this later, that's kind of referring to the payment stream and stuff like that. So when you are reading that, it tells you you have to be the owner of a note. The property must be secured by a lien, right? And that the promissory note that they're referring to in this section includes your retail installment contracts, right? So, like I was saying, letter A represents ownership of one or more promissory notes. Under that subsection, you have I1 and I2, which is directly secured by a first lien on a single parcel of real estate. There must be a lien and a note together, as these things together constitute the mortgage. And then if you could scroll down a little bit more, Auntie, to the next page, just a little bit. All right. So right here, it will tell you that, again, for the purpose of this paragraph, promissory note, when used in connection with a manufactured home, shall include a loan, advance, or credit sale as evidenced by a retail installment contract. So they straight up tell you what the promissory note is in this equation. And it is your contract, your retail installment contract. So that is the definition of what a mortgage is, right? And that is in coordination with all of the other federal laws in regards to mortgage, including RESPA, TILA, Graham, Leach, and Bailey, all of these things, right? So then, Auntie, if you want to switch over to the deed of trust now.
Yeah, I will. And what just to piggyback off of what he said when he said that it has to be two things in common with the evidence of debt and then a lien. So that goes back to what I was saying about they never perfected the lien itself.
Mm-mm.
And then you never went and accepted the deed itself because they were supposed to file it for you, the title company, supposedly, right? Because the title company is considered the holding company for you guys who have bought homes. Where did you have to send your money to? The title company. Where did you go close at? The title company, right? So they are the transfer agent in between you and the other party. So to get the funds. So the actual company that's pulling your getting the original issue discount is coming from the title company. And that's why they tell you the money got to be in by a certain amount of time, this, that, and the other, so that they can run it through because they are considered the holding company. Okay. And you want the deed of trust. All right.
All right. So now that we have that understanding of what the mortgage is from the Securities Exchange Act, let's see how what we're going to show as the mortgage, the note, and the deed are going to match up to what is required there. Now, deed of trust definitions. I have highlighted security instrument, which is this document, right? Because this document is a security instrument when it was dated, right? Who the borrower is, who the lender is, and then, as you can see, the trustee. So right here, they give you the definitions first off. They're going to tell you what everything means, who you are, and what your place is in the transaction. So they're telling you the lender, they're telling you DHI Mortgage Company in this case. The trustee is the public trustee of Arapahoe County, Colorado. MERS is the
So that's
mortgage
something
is
though.
the
How it hold on one second, nephew. So that's something though. How
yep.
can a county be considered a trustee? Aren't they supposed to be government? So are you a government or are you trustee? Think about it. Because they saying the trustee is the county. So that's how the county is able to come in and get you for taxes. But not just that, the county is the one that's holding your payment. Oh,
Mm.
that part. That they're gonna eventually say that you abandoned and then now it's a gift. So if you have your deed of trust out, you might want to have it out. Okay. But
Now,
okay, go ahead, nephew.
going into what Auntie said about how it looks like we are the ones writing this, you are, by signing this document, you are agreeing to designate them as your trustee. You see what I'm saying? Not knowing that you're able to edit this document and change the trustee because maybe you don't want the county to be your trustee, but you agreed to it when you signed this. But that's something that we'll get into as we continue. Now, the
Right. Let
definition of
me
merge.
one more thing, nephew. One more thing,
Mhm.
nephew. Are you on? You're not even right here yet. I'll wait till you get there. Oh yeah.
Oh yeah, I wasn't. Yeah, I'm gonna get down there. MERS is the Mortgage Electronic Registration System. If you have a mortgage, you probably know about MERS. You've probably dealt with MERS, looked through some stuff on MERS to find your documents. MERS is a separate corporation that is acting solely as a nominee for the lender and the lender's successors and assignees. Okay, that is
Ain't y'all the
very
lender?
important right there.
And
Because
y'all the
again,
lender.
yeah. So you are appointing them and giving them the right um for your successors for and so what they're talking about is successive assigning. This is why they're able to keep moving it over and over again because you told them that they can. MERS is the beneficiary under this security instrument. So they tell you the instrument is the deed. They told you that in the definitions right above here, right? But MERS is the beneficiary. And that you see that they bolded it because they want to make it very clear. Anything that they have bolded, that is required information. That means that there is a federal regulation saying that if you're going to include this information in here, you have to bold it. You have to make it pop out to the eyes so that people have a chance to review it, which is why you're supposed to be able to review all of this before you sign so you can make changes if you don't want that. Now, it tells you MERS is organized and existing under the laws of Delaware and has an address and telephone number, blah, blah, blah. So MERS is appointed as the beneficiary under this agreement. And you said that they were. This is all you right now. This is all you, right? Now,
And do you
note.
guys know who own MERS? Do anybody know who own MERS? The Mortgage Bankers Association. MERS is actually ran by Wells Fargo, PNC, Chase. All the major banks actually own MERS. And they are running up under the Mortgage Bankers Association. Their holding company is MERS Corp Holdings. Because remember, they got to have, where they transfer their money to and who's actually holding the funds. So that's MERS Corp Holdings will be the holding company. Okay. But then going back to where on E, where it says they are the nominee for the lender in the lender succession and assigns. Well, aren't you the lender? Last time I checked, you was the lender because they don't have any money. Everything has to come from us. So technically, MERS is there to help you. This is why you can log on to the MERS website and put in your information and the documents will pull up because you are the lender. You have the right to see those documents. For you guys that's already been on MERS and have put in your address or your name, most of your accounts will say that they've already been paid off. You will also be able to get the deed of trust and the promissory note. Well, probably not the deed of trust, but the promissory note. You'll be able to get that off of the MERS website and you will see the stamp for yourself that they stamped it and they sold it to the bank. But you're
Yeah,
able to see those things because you are the lender. I need y'all to stop thinking you get out the borrower box. You're not the borrower. You are the lender. Okay. So MERS system is for you, but they are using them. You nominated them based off of this deed of trust. You nominated MERS to be your nominee. Okay. All right, go ahead, nephew.
All right. So now the definition of note means the promissory note signed by the borrower and dated blah blah blah. The note states that the borrower owes the lender the full amount of money in US currency plus interest. They've promised to pay the debt in regular periodic payments, which is true because they owe you that money. And then loan, I want you to pay
Wait, before you go to loan. So when you go back to what note is, note means the promissory note by the borrower, dated, blah, blah, blah. But it says right here, plus interest, borrow as promised to pay this debt in regular periodic payments and to pay the debt in full no later than 2051, right? But if you're the lender, they're the borrower. Regular periodic payments seem like a payment that you pay every 30 days. Ain't that what periodic means? It's mean recurring, often, right? So the borrower is actually paying the lender and they're doing it every 30 days. Huh. Am I right? Don't y'all have to every 30 days? So if we the lender and we're supposed to be getting interest off of the security that we lend to them, then they are supposed to pay who? Us. So where's the payment? The one that's coming in your mailbox every 30 days or your email is the periodic paying, and they got to pay you that until 2051. But they have bamboozled everybody to make you think that you have to pay them that when they really supposed to pay you that. So they can always say, well, we paid you. You didn't want it, and you gave us some more money, and you it's a gift. Okay.
Yep.
But the deed is telling you what they're supposed to be doing. So when you understand the roles and you understand that you're the damn lender and that they are the borrower, and every 30 days they're sending me a regular periodic payment. Now I just got to figure out how I get my money and why am I constantly paying them, right? So that's that. Go ahead.
Hey, I hope y'all caught that because that's where it's at. So, loan means the debt evidenced by the note, right? Because again, the loan itself, right, in this case, this is a separate thing from the note in the deed. You see what I'm saying? Which is why that is the third element that makes up a mortgage, right? It's the promise to pay, the deed, and the what I'm gonna call intangible debt stream, right? Or what they're calling the debt evidenced by the note. In this case, the loan itself. You see, because it is a third element. There is the loan, there is the note, there is the deed, right? So the intangible debt obligation that doesn't exist, right? We're just going to call that the loan because that's what they refer to it as in the deed. So you're going to hear me referring to those three pieces as we break down the rest of this deed of trust and then going on to the note because the note is really the meat and potatoes. Like the deed, yeah. Can you keep on scrolling on to the next section? All right. So I've highlighted every single letter you'll see. But I want to go over a few things on this first page here. Firstly, applicable law, which means all controlling applicable federal, state, and local statutes, regulations, ordinances, and administrative rules that have effect of law, as well as all applicable final non-appealable judicial options, right? We have to understand that even though there's things that we're agreeing to, all of these are governed by federal law, right? Electronic funds transfer means any transfer of funds. Any transfer of funds. I want y'all to pay specific attention to these definitions because their wording is very slick. Like how they flip the roles up there to make it seem like you owe them money when they're really talking about paying you. It's the same thing here. Any transfer of funds other than a transaction originated by a check, draft, or similar paper instrument which is initiated through an electronic terminal, telephonic instrument, computer, or magnetic tape so as to order, instruct, or authorize a financial institution to debit or credit an account. Such term includes, but is not limited to, point of sale transfers, automated teller machine transactions, transfers initiated by telephone, wire transfers, and automatic clearinghouse transfers. Okay. Escrow items means those items that are described in section 3. You're obviously going to have to read section 3 in order to find out what that is, but we're going to get there later. Miscellaneous proceeds, because I mean, I really hope y'all are reading what you're signing here. It means any compensation, settlement, award of damages, or proceeds paid by any third party other than insurance proceeds paid under the coverages described in Section 5 for damage to, destruction of the property, condemnation, or other taking of all or any part of the property, conveyance in lieu of condemnation, misrepresentations of or omissions to, um, the value and or condition of the property. So there's another section where it talks about how in the same deed here that you assign all the miscellaneous proceeds to go to them, right? Which is basically telling them they can keep everything, right? All of that compensation. Now, RESPA, right? This is what we were talking about earlier. The Real Estate Settlement Procedures Act, 12 USC 2601 through the end of that chapter, and it's implementing Regulation X, 12 CFR 1024, as they might be amended from time to time, or any additional successor legislation or registration that governs the same subject matter as used in this security agreement. RESPA refers to all requirements and restrictions that are imposed in regard to a federally regulated mortgage loan, even if the loan does not qualify as federally related mortgage loan under RESPA. So when you read the Real Estate Settlement and Procedures Act, it tells you that there are certain requirements that must be fulfilled by these companies in terms of your mortgage documents, in terms of how calculations are to be done. And if anything is off, if any of the calculations are wrong in the numbers that they give you, if any of the disclosures are missing, it can void out the entire mortgage, which is why it's very important to understand what your rights are. Now, successor interest of borrower means any party that has taken title to the property, whether or not that party has assumed borrower's obligations under the note and or this security instrument. Now, I really want y'all to catch that one right there, right? Because again, if they are the borrower, any party that has taken title to the property, whether or not they have assumed the borrower's obligations. So that means that what they're trying to say is that someone can have successor interest without having the obligation to pay the note under this security instrument, right? Because the loan and the note with along with the deed together are what form the instrument. Okay. Now, transfer of rights in the property. The beneficiary of this security instrument is MERS, solely as nominee for lenders and lenders' successors and assignees, and the successors assignees of MERS. The security instrument secures to the lender repayment of the loan and all renewals, extensions, modifications of the note, and the performance of the borrower's covenants and agreements under this security instrument and the note. For this purpose, borrower irrevocably grants and conveys to trustee in trust with the power of sale the following described property in the located county. So then it assigns all of the transfer or all of the rights here. So again, we're agreeing to all of this. It's straight up telling you what exactly is going on. Did you have anything you wanted to say on this page, Auntie?
Yeah. Mhm. So you see how they did it as an irrevocable grant. It conveys to trustee. They made MERS be the trustee, but the beneficiary of this security interest is MERS. So MERS is the beneficiary. Solely as nominee for the lender, which is you, your successors, your family, or your kids, or whoever, and assigns to MERS. So it's looking like you assigned it to MERS. The security instrument secures the lender, which is you, the repayment of the loan, which is you, and all renewals, extensions, and modifications of the note. The performance of borrower's covenants, and it's a part on each one of you guys' document that has a part that talks under covenants. That's when they tell you that you could, X this out in 3 days, and that you are now a renter and no longer owner. And agreements under this security instrument and note for the purpose. The borrower, which is them, grants and conveys to the trustee. So who's technically getting paid? That's why MERS is is moving as the trustee up under your mortgage, right? But it does say it's irrevocable grants and conveys to trustee. Nothing in here say that you can't change the trustee. So at any time you can remove MERS as being the trustee, the power of attorney form, and assign who you want to be the trustee. Because technically, don't it? I mean, by reading this, it looks like you wrote it. You're the lender. You are the one who has decided to allow MERS to be the beneficiary. Why should MERS be the beneficiary when it should be your trust? Right? So they're paying your beneficiary, which is MERS, instead of you, because you assign MERS to be it. But nothing says nowhere that you can't change the trustee at any given time. This same document right here, this deed of trust, you can copy and paste all of it, literally, word for word. Take whatever name, MERS name, gone, your trust name there. Notarized, certified, file. You have the power to change your deed of trust. Okay, we'll go more into it tomorrow how to do it, but it was a reason I was telling y'all to get silver or the silver certificate, because that is lawful funds, not legal, but lawful, right? So we know lawful is common law, and nothing can outdo lawful funds because it trumps everything. Because when you get to transferring everything over, you have to say that you sold your house to. Why do you think you can do a quick claim deed, right? This is a deed of trust, right? So why do you think you're able to go down to the county tomorrow if you wanted to and change the deed over to who it needs, whoever you choose to, right? So that means that you can change this entire document. And whatever is the last one in is the last one that stands. Okay. But I want y'all, as y'all reading your mortgage documents, know what your position is. Do you want MERS to be your beneficiary? Why is MERS benefiting off of your security when it should be you? Which means instead of them sending the payment to MERS, which is going to end up going to Fannie Mae and Freddie Mac and all of them, it should be going to who you choose as a nominee. Okay. Okay, you go ahead and
All right. This is just continuing to talk about what all they transfer um to the county and the trustee. But again, it says together with all the improvements now or hereafter erected on the property, all easements, appear, I don't know what that word is, and fixtures now or hereafter part of the property, all replacements and additions shall also be covered by the security instrument. All the foregoing is referred to in the security instrument as the property. Borrower understands and agrees that MERS holds only legal title to interest granted by borrower in the security instrument. But if necessary to comply with law or custom, MERS has the right to exercise uh, uh, any or, and then if you keep going, there's more to that. But basically, again, it's just saying MERS is able to exercise all of the interests, but not limited to the right to foreclose and sell the property and to take any action required of the lender, including but not limited to releasing and canceling this security instrument.
so if MERS is able to do that because MERS is the beneficiary, that means that if you change who the beneficiary is, then they no longer have the right to foreclose or to sell the property at all. It'll only be who you transfer lawful ownership to, which is going to be your trust. You want to put it in your trust, not cousin Mary. You want to put it in the trust. Okay. Now you go ahead.
All right. Now, borrower covenants. This is, and we're finishing up the definitions here because everything up above where you see number one, this is all definitions so that we understand what these things mean when these terms come up throughout the rest of the deed, right? Now, borrower covenants that the borrower is lawfully seized of the estate, hereby conveyed, and has the right to mortgage, grant, and convey the property, and that the property is unencumbered except for encumbrances of record, which is important. It has to be unencumbered unless it's on the record. Borrower warrants and will defend generally the title to the property against all claims and demands subject to any encumbrances of record and liens for all taxes of the current year not yet due and payable. All right. So again, these are the covenants, what the borrower is agreeing to do. Protect the title. The security instrument combines uniform covenants for national use and non-uniform covenants with limited variations by jurisdiction to constitute a uniform security instrument covering real property. Because the rules are
Before you finish
different.
that, before you finish that, did anybody notice the way that seize is spelled? Do you notice that that is not SEIZE? That is SEISED.
Mm-hmm.
That means past tense. See, the way our brains has been trained, you will look right at that and be like, thinking that it's seized. And then and look at the word that the borrower is lawfully seized of the estate. That is past tense and lawfully. It didn't say legally. It said lawfully, and we know lawfully and legally are not, and legally is not the same thing. Okay, and it's telling you it has the right to mortgage, grant, and convey the property, and that the property is unencumbered. Well, that's not true, except for encumbrance of record, right? So this is why they never perfect the record, because if it's perfected, then they're not able to mortgage anything, which is why your paperwork down at the county or at the deed recorder's office is going to always say unperfected. The county office is in on this as well. Like they know this and they're banking on you not to know it. Okay. I'm sorry, nephew. Keep.
Absolutely, absolutely. No, like I said, we ain't even covered nothing yet. Y'all think we covered something? We ain't even covered nothing. So, uniform covenants, right? Borrower and lender covenant and agree as follows. So, there is certain things the borrower agrees to. There are certain things the lender agrees to. These are the uniform covenants that you both agree to. Now, number one, payment of principal, interest, escrow, late charges, all of these things. I want y'all to pay attention to this right here. Specifically this section that I have highlighted because everything else in there is important. But look, payments due under the note and this security instrument shall be made in U.S. currency. Now, again, the way our brains are programmed, you're just going to look right past that. Why do they say U.S. currency? Because there's a lot of things that can be considered U.S. currency. But now check this. However, if any check or other instrument is received by lender as payment under this note or security instrument is returned to the lender unpaid, the lender may require that all subsequent payments due under this note and security instrument be made in one or more of the following forms as selected by lender: cash, money order, certified check, bank check, treasurer's check, cashier's check, provided any such check is drawn upon an institution whose deposits are insured by a federal agency, instrumentality, or entity, or electronic funds transfer. Okay. Payments are deemed received by the lender when received at the location designated in the note or at other such location as may be designated by the lender in accordance with the provisions of Section 14. Lender may return any payment or partial payment if the payment or partial payments are insufficient to bring the loan current. Lender may accept any payment or partial or hold on. Lender may accept any hold on. Lender may accept any payment or partial payment insufficient without waiving. Sorry, I lost myself here.
While you're
Without
looking for
waiver of.
yourself, now I want to go back. While you're looking at
Mhm.
it, looking to get your footing back, I want to go back to the word currency. So we have been trained to believe that currency is the green money that's in your pocket. Okay. But currency, and as far as dealing with securities, is called circulation of medium of exchange. Circulating medium of exchange is what currency means when they say currency. So then when you like medium exchange, what is being exchanged? Any coin, you see it says coin, and I will pull this up. It says coin, okay? Circulating medium of exchange is any coin or note passing without endorsement. So when they say give them currency, you gave them that because you didn't put an endorsement on there, did you? You signed it.
Nope.
Signing is not an endorsement. So when they keep talking about lawful funds under the United States, we need currency. Well, you gave them that because that was in a medium of exchange, which is the true definition of currency. Okay. Currency in circulation refers to the amount of cash in any form of paper notes or coins within a country that is physically used to conduct transactions between consumers and businesses. In the form of paper notes, what is that? That you gave them, right? A note. You gave them a note. And you gave it to them without an endorsement. So you technically did give them currency because currency and money does not mean you're good on nephew.
Yep.
All right. I
Um,
need to go down some more.
yes. But I want y'all to pay attention to that payment of interest section because basically what they're saying
It's
is if we send you the payment every month and you send it back, we're allowed to do what we want with it. That's the gist of that, and a few other things. But yeah, if you want to keep on scrolling down there, Auntie. So I want y'all to look at number 2 here. Application of payments or proceeds. Except as otherwise provided in Section 2, all payments accepted and applied by lender shall be applied in the following order of priority. First, to the mortgage insurance premiums to be paid by the lender to the secretary or the monthly charge by the secretary instead of the monthly mortgage insurance premium. Second, to any taxes, special easements, leasehold payments, or ground rents, fire, flood, and other hazard insurance premiums as required. Third, to the interest due under the note. Fourth, to the amortization of the principal of the note. And fifth, to the late charges under the note. Any application of payments, insurance proceeds, or miscellaneous proceeds to principal due under the note shall not extend or postpone the due date or change the amount of the periodic payments. Right? Funds in escrow. And then Auntie, if you want to keep scrolling, because I just have highlighted certain sections, I have highlighted every different one. But each of these different numbers that you're seeing is a different section that you need to read and understand. So in here, they're talking about escrow and everything that goes on with escrow. So breaking down all of this is going to be a lot. But remember, it said under section 3, the definition of escrow. So now we're reading section 3 right here. And this is going to tell you a whole lot of stuff talking about RESPA, talking about a whole lot, right? And then I'll tell you if you want to
It'll
keep
tell you
scrolling.
too, and then it's showing you too that the funds that's in escrow, because all of your funds are in escrow. Everything that you pay, your original issue discount that they got from the window is all in escrow. So if it's a borrower shall pay to lender on the day periodic payments are due under the note, that's your due date, until the note is paid in full to provide for payments of the amounts due, taxes and assessments, and other items which can attain priority over the security interest as a lien or an encumbrance on the property. So that means your taxes is already paid for too. Why? Because it's in escrow. So whoever's holding your funds in escrow is responsible for your taxes. Okay, keep going.
Yep. Now it will even tell you that all of the items in there are called escrow items at origination or any time during the term of the loan. Lender may require that the community association dues, fees, and easements, if any, to be escrowed by borrower or no, to be lender. All
So
notices
community
amounts to be
associate,
paid under this section. Mm-hmm.
and when you think about community association dues, what's that? Your homeowner association. Like literally everything was in escrow. Even the amount for the 30 years that your loan is, times whatever the home association fee is, was already paid, right? This is why if you don't pay your home association dues, the home association can foreclose on you, but the money is in escrow. But you default on it because you told them they got it. They're paying you, but you told them they got it, right? So that's how when people like, how can a home association? Because you agree with it within this fees and assessments. That's the land itself, right? Any dues, so they disguise it as a home association, and we're here to make sure you cut the grass. No, they're there and they do what they want because they were added to your mortgage contract. And if the finance charge is the sum of all charges, and this is a charge, the tax is a charge. Why the hell are we paying any more money? Right? Shouldn't it be coming out of escrow? So,
Yep.
all right, never go ahead. I need to go down. Or are you good?
Oh, I was gonna read just a little bit more, real
Okay,
quick. Oh
go
wait,
ahead.
hold on. Here it is. Borrower shall pay the lender funds for escrow items unless the lender waives borrower's obligation to pay the funds for any or all escrow items. Because if you waive that obligation, we're actually going to keep reading. Lender may waive borrower's obligation um, here we go. Lender may waive borrower's obligation to pay lender funds in the event of any such waiver. Borrower shall pay directly when and where payable the amounts due for any escrow items, which payment of such time period as lender may require. Borrower's obligation to make such payment and to provide receipts shall for all purposes be deemed to be a covenant and agreement contained in this security instrument. As there is a phrase, covenant and agreement used in section 9. If borrower is obligated to pay escrow items directly pursuant to a waiver and borrower fails to pay the amount due for an escrow item, the lender may exercise its rights under section 9 and pay such amount in any or all escrow items at any time given by a notice given in accordance with section 14, and upon such revocation, borrower shall pay to the lender all funds and in such amounts that are there and then required under this section 3. Lender may at any time collect and hold funds in an amount sufficient to permit the lender to apply funds at the time specified under RESPA and not to exceed the maximum amount a lender can require under RESPA. Lender shall eliminate the amount of funds due on the basis of current data and reasonable estimates of expenditures of future escrow items in accordance with applicable law. So That's all I needed to read from there. And also, when y'all are seeing there, it said any waiver must be done in written form. Any such waiver may only be done in writing. That's the other important thing. And then, Auntie, if you wanted to keep scrolling. So we got charges, liens. Borrower shall pay all taxes, assessment, charges, fines, impositions attributable to the property. So again, that's not you, which can obtain property over the security instrument, leasehold payments on ground or rent the property, if any, community association dues, fees, and assessments, if any, to the extent that these items are escrow items, and the borrower shall pay them in the manner provided in Section 3. Number 5, property insurance. That just tells you you're required to keep all of the insurances, and if you fail to maintain insurance, what's going to happen? Um, to the property. And also, if you Auntie, if you could scroll down just a little bit more so I can see this paragraph right here. All insurance policies required by lender and renewals of such policies shall be subject to the lender's right to disapprove such policies, shall include a standard mortgage clause, and shall name the lender as the mortgagee and or as additional loss payee. Lenders shall have the right to hold the policies and renewal certificates. If lender requires, borrower shall promptly give to lender all receipts of unpaid premiums and renewal notices. If borrower obtains any form of insurance coverage not otherwise required by the lender for damage to the structure of the property, such policy shall include a standard mortgage clause and shall name the lender as a mortgagee and or as an additional loss payee, right? So that is very important because when it's talking about insurance policies and everything like that, it's saying if you're getting any additional insurance or anything like that, you got to add them onto it. Um, and what else? I don't know why I'm drawing a blank, but y'all get it. Honestly, if you keep on scrolling to the next section, but again, you need to read all of these because they tell you what they do. Occupancy. Borrower shall occupy, establish, and use the property as borrower's principal residence within 60 days after the execution of the security instrument. Shall continue to occupy the property as borrower's principal residence for at least 1 year after the date of occupancy, unless lender determines that this requirement shall cause undue hardship for the borrower, or unless extenuating circumstances exist which are beyond the borrower's control. So again, you have to know what you're agreeing to. You're agreeing to stay there for and make it your primary place for at least what did that say? 60 days. Yes. Number 7, preservation, maintenance, and protection of the property. You agree not to destroy the property. That one's pretty self-explanatory, right? Number 8, borrower's loan application. Borrower shall be in default if during the loan application process, borrower or any persons or entities acting in the direction of the borrower or with the borrower's knowledge or consent gave materially false, misleading, or inaccurate information statements to lender or failed to provide lender with material information in connection with the loan. Material representations include, but are not limited to, representations concerning the borrower's occupancy of the property as borrower's principal residence. Okay. Protection of the lender's interests in the property and rights under the security instrument. You can keep scrolling, Ati. I wasn't going to read anything from under this one.
Nothing under 9.
Uh-uh.
That's what they be wanting y'all to do. Abandon the property. Don't abandon it.
Do not.
Don't abandon it. And then two, before we go further with that, if they're requiring under this deed of trust that you are supposed to keep up the property and all of the things that you repair within the property itself, because they got you as you're the borrower, right? And if it's their house, why are you paying for it, right? So you can put a mechanic's lien up under your own house. Nothing can overdo a mechanic's lien. You don't have the mechanic's lien don't just mean you fix the car. If you change the light bulb, okay, that's all about being able to protect your asset, especially when you're going through these processes to stop them from trying to foreclose and take because they cannot do a mechanic's lien. Just a little something out there. All right, here you go.
But again, each of these tell you, and each of these covenants are very important. But this is the one I was talking about earlier. Assignment of miscellaneous proceeds. Because remember, it told you miscellaneous proceeds was all payments besides insurance that was coming from a third party, I believe is what it said up there. So all miscellaneous proceeds are hereby assigned and shall be paid to the lender. So this means that all of the extra money that they're making on the property, you're assigning it to them. That's money that you are entitled to as the person who tendered this instrument. But you're assigning it to
But now,
the
what is the property
company.
considered? What is the property is considered though? Is the property your address? Uh-uh. The property is the security that you take. So all the money they're making on the secondary market off of you is supposed to be assigned to you, but you gave it back
Yep.
to them, which is why they're saying it as a gift. So when you look at the word property, don't think about the structure in which it is that you live in. Okay, because it's not that. The property is the security that you gave them because technically the security belongs to you. You granted it to them in exchange for regular periodic payments, and any miscellaneous funds is supposed to go to you, right? You ever notice that if you're in a car accident or if you got property damage and you get a payment from the insurance company, right? Why is it in your name? You have to sign it over to them, right? Things to make you go, because technically it's your money. Your name is the only one on the account. They're just acting as a fiduciary. They're just acting as a trustee. Um, they're just acting as a trustee. Okay. You want me to go down?
Yes. But I want y'all to pay special attention because like I said, the amount that you'll miss, and they go even more into that under that same section. Mm-mm-mm. All right, so number 11, uh, borrower not released, forbearance by lender not waiver, extension of time for payment modification or modification of amortization of the sum secured by the security interest granted by lender to borrower or any successor interest of borrower shall not operate to release the liability of borrower or any successors in interest of borrower. Lender shall not be required to commence proceedings against any successor in interest of borrower or refuse to extend time for payment or otherwise modify amortization of the sum secured by the security instrument by reason of any demand made by the original borrower or successors in the interest of borrower. Any forbearance by lender in exercising the right of remedy or including without limitation lender's acceptance of payments from third persons, entities, or successors in interest of borrower or in amounts less than the amount due shall not be a waiver or a preclude of the exercise of the right of any remedy. So basically, they're saying that even though they're going through MERS to do all of their stuff, they're not giving up any of their rights, essentially. Joint and several liability co-signers, successors bound, anybody else who signs onto the agreements, anything like that. Co-signers, again, dealing with successors and assignees. So anyone who touches the contract at any point in their liability in relation to the instrument is described under Section 12. And then Section 13, loan charges. These things are really self-explanatory, but when you read more into them and understand what it's talking about, and you understand why some of these disclosures are there in accordance with RESPA and in accordance with Graham, Leach, and Bailey and TILA, why some of this is in here is going to make a lot more sense. But yeah, so they're describing to you the loan charges. And then, Ati, if you want to keep scrolling to the next one.
Before I scroll back to number 12. So husband and wives that have co-signed for each other, right? Whoever is the co-signer, it clearly states that you are not obligated to pay the sum secured by the security interest, because technically the main signer, whoever is first, they are the one who executed the note, right? But the co-signer is not. So you know how a spouse will die and they'll say, "Oh, it's your turn. You have to pay for it because you're the co-signer." Or even with the car or etc., you co-sign and then now the debt is on your credit report. That is illegal. It clearly states that the co-signer is not obligated to pay the sum secured by the security interest.
Yep.
They're not. Agrees that the lender and any borrower can agree to extend, modify, forbear, or make any accommodation with regard to the terms of this security interest without the co-signer's consent. Let's go back to how in the beginning of this class, I told you guys that you guys got the right to change this up. I didn't make that up. It's right here. It says that the lender, you, and any other borrower can agree to extend, modify, forbear. Why you think you can do a forbearance? Or make any accommodations with regard to the terms of this security interest or the note, because these are not the same thing, without the co-signer's consent, which means you don't need their consent to change this damn form to be beneficial to you instead of beneficial to MERS and the banks and everybody else who has their hand on your security interest that you so freely gave. So if you wanted to know how you're able to do it, it's in their own agreement right here. It tells you that you can assign, that you can change, that you can extend, and you don't need nobody's permission because you
No one's
are the one that
consent.
executed the note.
That's why I highlighted every single one of these sections, because though we don't have time to read all of it, because if I was trying to break down everything that I'm covering, we wouldn't even get onto the note. But y'all have to understand, they straight up tell you these are your rights. So when the companies are trying to say, "Oh, well, you can't do this," well, actually, it says I can in the contract, right? So loan charges, notices. Can you scroll down so I can see the notices paragraph a little more? All right. So, oh, a little bit up. All notices given by borrower or lender in connection with this security instrument must be in writing. Please, for the love of God. I know y'all want to be calling people, but all notices must be given in writing. Any notice to borrower in connection with this security instrument shall be deemed to have been given to the borrower when mailed by first class or when actually delivered to borrower's notice address if sent by other means. So again, notice how it gives you two options. As soon as you mail it, it is considered delivered, the notice. So any of this madness is we didn't get it, we didn't know. No, that's not what it is. I gave you notice. It was delivered as soon as I mailed it. That's not my fault. Okay? Y'all gotta understand.
And why is
Notice
that?
to
Does anybody know why as soon as you mail it, it's considered delivered?
raise your hand because I know the answer. Let's take a look at these hands. I saw, who did I see first? Hold on. Oh Lord.
And I just picked somebody.
Sorry, y'all. I'm not used to doing this on my computer. It's gonna take me
Chantel.
a second.
It's good. I got it.
Okay.
Chantel. Chantel. Chantal. Urena. I see you writing. Brent. Bristol.
Hey Auntie, hey Caleb, hey everybody, grand night. Auntie,
Hello.
I'm thinking it's considered delivered once you mail it because we have the proof that we mailed it and the postmaster general is what we stand on or under. I don't know. That's what I'm thinking.
Good answer, but not the right one. But it's a good answer. You're close. It does have a lot to do with the fact that it was sent to the postmaster general, right? Dare. Hey, Dare. You can unmute.
Yes, I think is considered delivered because it's registered mail.
Okay, what else? It's registered mail, but I'm looking for something in particular. So y'all notice that anytime you got to mail anything back to these companies, it's a what? PO box, right?
Mhm.
So what is a PO box considered?
Electronic fund transfer.
Nope.
Oh, log box funding.
A lockbox funding. So and then and the post office is who? That side of the post office. What are they considered?
Bank.
There you go. So it's going from one bank to another bank within the lockbox funding. So as soon as they scan it in, these companies get a notification that it's on its way. Why do you think it'll say your bill is due December the 15th by 5 p.m.? Well, what closes at 5 o'clock? The post office does, right? And
Yes.
then they got a lockbox service company that comes in and they get them and they process them. But as soon as it's scanned in with the little barcode, that's why they send you an envelope, right? So that the PO box can show. So you're doing banking to banking, right? Because if the treasury is the head of the bank, they're the head of everybody, which is why I tell everybody get a PO box because it keeps you in the private. You're doing private matters that will stay in the private, right? Once you get it to your house, you've now put it in the public and you now committed securities fraud, right? But if you keep it banking and banking, right? Because the post office is a bank, you're sending it to a bank, you're keeping it private. And now, if there's any issues, now you can invoke the postmaster general because you kept it in the private, you kept it bank to bank. You got it? But good
Yeah.
job. All right. Where you want me to go now, Caleb?
I was just going to finish up with there. The notice address shall be the property address unless the borrower has designated a substitute notice address by notice to lender. Borrower shall promptly notify lender of borrower's change of address. If lender specifies a procedure for reporting borrower's change of address, the borrower shall only report change of address through that specified procedure. And then again, any notice in connection with this security instrument shall not be deemed to have been given to lender until actually received by lender. If any notice in this security instrument is also required under applicable law, the applicable law requirement will satisfy the corresponding requirement under the security instrument. And then number 15, obviously governing law. This security instrument shall be governed by federal law and the law of the jurisdiction in which the property is located. All rights and obligations contained in the security instrument are subject to any requirements and limitations of applicable law. Applicable law might explicitly or implicitly allow the parties to agree by contract or to remain silent, but such silence shall not be construed as prohibition against agreement. And then if you keep scrolling for me, Auntie, by just a little bit up. By contract, in the event that any provision or clause of this security instrument or the note conflicts with applicable law, such conflict shall not affect the other provisions of this security instrument or note which can be given effect without conflicting the provision, right? Okay. So, and then I'll say, yeah, if you could scroll down a little bit more. Borrower's copy. Borrower shall be given one copy of the note and of this security instrument. You're supposed to get a copy. Now, this is the one that I really want y'all to pay attention to. Transfer of the property or beneficial interest in borrower. As used in this section 17, interest in the property means any legal or beneficial interest in the property. This is including but not limited to those beneficial interests transferred in a bond for a deed, contract for deed, installment sales contract or escrow agreement, the intent of which is the transfer of title by borrower at a future date to a purchaser. And that's just the first part. A bond for a deed, contract for deed, installment sales contract or escrow agreement, the intent of which is the transfer of title by borrower at a future date. Okay? Now, if all or any part of the property or interest in the property is sold or transferred, or if borrower is not a natural person, immediate payment in full of all sums secured by this security or the lender may, without the lender's prior written consent, the lender may require immediate payment in full of all sums secured by this security instrument. However, this option shall not be exercised by the lender if such exercise is prohibited by applicable law. If lender exercises this option, the lender shall give borrower notice of acceleration. The notice shall provide a period of not less than 30 days from the date the notice is given in accordance with Section 14, within which the borrower must pay all sums secured by the security instrument. If borrower fails to pay these sums prior to the expiration of this period, lender may invoke any remedies permitted by the security instrument without further notice or on demand on borrower.
Let me say
so there, yeah, I was gonna say
this right here. If any or all part of the property or interest in the property is sold or transferred, or the borrower is not a natural person. Well, you the natural person, correct? You ain't the borrower, but they are the borrower and they are not a natural person. Nope. Due to the fact that they are not a natural person, when you get your beneficial interest corrected with correcting these forms, without lender's prior written consent, you may require immediate payment in full of all sums secured by the security interest. Why do you think you can call them and tell them to send you a payoff note? But that's technically what they're supposed to pay you. And at any time, without any written communication, you can call the note forward because they have transferred the bond over to somebody else and they keep selling it. Well, if you don't like that, you can call the note due at any time. Because technically, you are the lender. You are the one with the beneficial ownership. They are not a natural person. You see, it says not a natural person. That's why when people did like a buy from the, like a, what do they call that? When you buy directly from the home owner, you're doing like a land contract or something, then it can't be called due because that is still considered a natural person, right? But if it's sold or is it transferred, which we know that they are doing, they transferred their interest. That's why you keep getting a new servicer. Oh, we transferred it to this servicer. Well, guess what? You can be like, well, I don't, and that's why the new servicer wants you to sign a new contract, or they'll give you something to sign or say, just logging in. If you get a new servicer, they send you a login, you log in, boom, that's the contract. If they transfer the servicer and you never log in, you write on your, I do not wish the contract or whatever you do, guess what? The servicer can't do anything. They've already sold it to them. That's just like a debt collector calling you. You know the debt was from Amazon, but you got JJ Ross and Associates calling you, right? Talk about you owe us. That's why you can make them validate the debt. The debt is not with you. So if they're doing anything with your security that you don't like, you have the right to immediately call it due, which is why if any of y'all picked up the phone right now and called your lender and say, hey, send me a payoff quote, they have to send it. You just got to know how to properly send it back to get what belongs to you. They played us. Dagmar, you just keep putting your hand on your head like these people can't. Look, you at the bottom of my screen. You like, what the hell? But seriously, when you really get to breaking this down and you really get to reading it, you like, wait a minute. And when you got that foundation and you know what these words mean, and you know that you're really the lender and not the borrower, you like, wait a minute. And they made sure they put not a natural person and a beneficial interest in the borrower is sold or transferred. They don't have a beneficiary interest, right? You gave the beneficiary interest over to MERS. MERS ain't the one that be foreclosing you, it's Bank of America. So they don't even have beneficial interest. The only thing they got is a job to act as your fiduciary and your trustee to make sure that you're getting paid everything you're supposed to get paid that's in escrow, and that you're getting it on a regular periodic payment, principal due, payment due, right? So I just wanted to, because this is a mighty statement right here. A mighty. The borrower should be given a copy of the note in the security agreement. Don't you give them a copy? You got a copy, they got a copy, right? You transfer that beneficial ownership to you, your trust. You knock them completely out the box. If you remove them as trustee, you take away their beneficial ownership, they can't do dolly squit to you, nothing. Okay? And call the note due. They planned. They done sold it. They done transferred it without and they did it without prior written consent. But this is what it says. You gave them the power to do these things because you are the lender. They don't need your written consent to do nothing that they're doing. But if you don't like what they're doing, call it due. Period. Okay? All right, nephew, go ahead.
Hey, I could not have said it better myself. Now, borrower's right to reinstate after acceleration. And then number 19, Auntie, if you could scroll down. I just wanted to focus on that one real quick.
And before you do that, that's why they say here, you got 30 days. Your notice normally due every 30 days, right? Not less than 30 days from the date of the notice in accordance with Section 14. The borrower must pay sums secured by the security interest. So all the sums that they secure now has to be paid to you. And when it talks about the lender may invoke any remedies permitted by the security interest without further notice or demand on the borrower, that's you suing them. That's you suing them. They're trying to make it seem like, oh, they can know up under the law say that's your money, right? Yep. And you don't need their permission to sue their ass after you send them notification. They got to do what they got to do. They don't do it. 30 days. Ain't no, they'll get a notice of default opportunity to cure. Hell no, you got a notice of default. I'm taking you in. Period.
That's it.
Because under the law, I gave you 30 days from the date that the notes was given. Right? That's just like when you switch your house over to your trust or wherever it is that you take it to, right? You change it on the county records, but people always forget the part to let them know you've changed it. You got to call them. I would do it in writing and call. I've changed the debt over to such and such, to the trust, right? You have to let them know. And we already read that you can change this shit whenever. It's in their paperwork. So all that, oh, you can't move it to a trust. Well, section such and such and this note say that I can, right? So you do it on a county level, but you have to also make them aware. They have 21 days to contest what you did. But can they really contest it? No, ma'am, no, sir, they cannot, because this is your damn note. They can't say, oh, no, we're not going to transfer. You can't put it in your trust name. You put it on the county record first. Once that shit is recorded and it's in a book, you send them a copy of that along with a letter, you're fired. You're fired. Period. You're fired. I'm done. You ain't been doing your job as making sure me, the true beneficiary that's supposed to be getting paid, you sending it to MERS. MERS saying, oh, MERS saying, well, you say I can have it because you never came and got it. We're not doing that no. Okay. So fire that. Go ahead.
All righty. Number 19, sale of note, change of loan servicer, notice of grievance. The note or a partial interest in the note together. Hold on. Yeah. So this is the part I really want y'all to pay attention here. The note or partial interest in the note together with this security interest. So again, this is the three elements that we're talking about. The note, partial interest in the note is what they're referring to as the loan or the intangible debt obligation. With the deed, the security instrument can be sold one or more times without prior notice to borrower. So when you're selling it, all three of these things have to be sold together, right? A sale might result in a change in the entity known as the loan servicer, which we know who the loan servicer is from the definitions, that collects periodic payments due under the note in the security instrument and performs other mortgage loan servicing obligations under the note, the security instrument, and applicable law. There also might be one or more changes of the loan servicer unrelated to a sale of the note. If there is a change of the loan servicer, the borrower will be given a written notice of the change, which will state the name and address of the new loan servicer, the address to which payment should be made, and any other information RESPA requires in connection with a notice of transfer of servicing. Because again, RESPA has requirements for notices and how they're supposed to do that. And if you're not properly notified under RESPA of a transfer, it can invalidate it, right? If the note is sold and thereafter the loan is serviced by a loan servicer other than the purchaser of the note, the mortgage loan servicing obligations to borrower will remain with the loan servicer or be transferred to a successor loan servicer and are not assumed by the note purchaser unless otherwise provided by the note purchaser. Because what they're telling you right here is that they can transfer the note without selling the loan. You see what I'm saying?
But not
They're
just
saying
that.
they can.
Not just that. Not just that. What is the servicer? What is the servicer's job? Can the servicer foreclose on you? Right? They only have servicing rights. So if they're servicing you, if I go to the restaurant, I'm going to be served by a waiter. That means they're giving me something, right? Because you're being served. So under mortgage, a servicer typically processes your loan payments, responds to borrower inquiries, because when you call, who do you call? The servicer, keeps track of the principal and interest paid, manages your escrow accounts. But what rights do the servicer really have? Are they supposed to be accepting the payment from you? But if they're there as a servicer for you. So the servicer is acting as a what? Holding company? Y'all getting this? So as I said earlier, that if you never agree to the servicer, you now do not have a contract with them. Okay. But they the servicer, who they supposed to be paying? Or are you supposed to be paying them? They're holding your principal and interest. And if you know all of those funds belong to you, that part. Okay, go ahead.
Borrower, not third-party beneficiary, to contract of insurance. Mortgage insurance reimburses lender or any entity that purchased the note for certain losses it may incur if borrower does not repay the loan as agreed. Borrower acknowledges and agrees that the borrower is not a third-party beneficiary to the contract of insurance between the secretary and the lender, nor is the borrower entitled to enforce any agreement between the lender and the secretary unless specifically authorized to by applicable law. Assigning the insurance, hazardous substances. And then if you want to keep on scrolling, Auntie, to the next page.
Before we scroll, borrower is not third-party beneficiary to the contract, right? That's why your bank name ain't never on that contract, because they the third party, right? Their name is never there. But this also says mortgage insurance reimburses lender or any entity that purchased the note for certain losses it may incur if the borrower is not paid a loan. So wait a minute. It's saying that if you don't pay, because they got you as the borrower, or they don't pay, that the mortgage insurance that you have actually reimburses them for anything that's going to be, what in the world? Where it go? Oh, for anything that's going to be lost, right? So how are they foreclosing if they never take a loss?
Again, look at who you assign the insurance to. If they're the ones getting paid, what?
But then it also tells you that if you the lender ain't paid you, even though they did, because they send it every 30 days. That means you can file insurance on them. Just a little thought. Okay, keep going.
Could you scroll to the next page? Grounds for acceleration of the debt. Can you keep scrolling? I think there was one more thing I had highlighted, one like an actual section. But if not, it was just the rest of the covenants. I think there's 20. Oh yeah, if you scroll to the next page, I have some stuff that I wanted to talk about.
This one? Is it this one talking about the assignment of rents? Because they supposed to be paying you. Transfer to the lender all the rents and revenues of the property.
Oh yeah, so yeah, this is the one. So the non-uniform covenants. So we just finished with the covenants that were uniform. And then these are the non-uniform covenants, and these are the things that are only going to apply in certain jurisdictions, depending on whether or not it's uniform or not. But borrower unconditionally assigns and transfers to lender all the rents and revenues of the property. Borrower authorizes lender or lender's agents to collect the rents and revenues and hereby directs each tenant of the property. Who are the tenants? I don't have that portion of the mortgage contract where it lists who the tenants are, but it hereby directs each tenant of the property to pay the rents to the lender or the lender's agents. So, however, prior to lender's notice to borrower or borrower's breach of any covenant or agreement in the security instrument, borrower shall collect and receive all rents and revenues of the property as a trustee for the benefit of the lender and the borrower. This assignment of rents constitutes as an absolute assignment and not an assignment for additional security only, right? If lender gives notice to breach to borrower, all rents received by borrower shall be held by borrower as trustee for benefit of lender only to be applied to the sums secured by the amount of the security instrument. B, lender shall be entitled to collect and receive all of the rents of the property, and each tenant of the property shall pay all rents due and unpaid to lender or lender's agent on lender's written demand to the tenant.
So who's the agent? You assign MERS to be the agent, right? You want to accelerate your stuff. Tell MERS to get it together. Or move MERS out of the way, put yourself there, your trust there, excuse me, and make them accelerate, right? Because you can call in the note at any time because they're in violation of it. Okay.
Yep. Acceleration remedies and other notices. And then if you just scroll down to the last page, I have one more thing right here. Now, this is the important part here. Release. Upon payment of all sums secured by the security instrument, lender shall request that the trustee release the security instrument and shall produce for the trustee duly canceled all notes evidencing debts secured by this security instrument. Trustee shall release the security instrument without further inquiry or liability. I hope y'all see how they playing in your face right now. Borrowers shall pay any recordation costs and statutory trustees' fees, which again, if you're assigning anyone other than your trust as the trustee, any fees that you're paying in relation to that is your own fault. But then homestead, because we were talking about this waiver of homestead. Borrower waives all right of homestead exemption in the property. Why would you do that? Why?
But it's crazy though, right? It tells you that you waive your homestead, but if you call your county, your state taxation's office
They
and
fills it
ask
out though.
them to provide you with all of the homestead um, exemptions that has been filed on your address, when you pull it up and they give it to you, you're going to see that MERS put themselves down as the beneficiary and that the bank put their name down as the borrower, right? So everybody, every house has a homestead exemption on there. I talked about it once before on my page. I even put it up. A homestead exemption is a foreclosure exemption. So, but wait a minute. If they're filing it every year because it has to be filed by April the 1st, here we go with this quarters, right? April the 1st is the new year, okay? It has to be filed by April the 1st. You go down and you file a foreclosure homestead. If you file a foreclosure homestead, that no one can foreclose on your property. Nobody, because you have a exemption put in there. But the bank files it every year, put MERS down or whoever they got in your contract as the beneficiary, and the bank put their self down as the borrower. That will definitely help you when you're doing this because they admitted to the fact that they're a borrower. You guys are able to get this from your taxation office. Okay? They have the filing of it because that's where it's filed at. That is where you get the document to be able to go file it on the record. So what happens is, say, when I first posted it, a few of y'all went and did the foreclosure homestead exemption. That means you're good for all of 2024 that they cannot foreclose on you unless it's a refinance. That's why they wants you to be so quick to refinance because you lose a lot of your rights. Whether it's a refinance or if it's a mechanics lien. But a mortgage foreclosure exemption stops any foreclosure on the property that has anything to do with the promissory note. It's on my page somewhere. I guarantee you it's on the receipt dropper page. And it's not as much on there as the Path to Freedom page. I put up the whole entire thing. There's 9 different exemptions that you can get that this homestead foreclosure exemption fall up under outside of the 2 that I just named. A mechanics lien. Why a mechanics lien? Because only a living person can say that they did work for you, that you didn't pay them. Right? So all I say is as long as these people keep talking about this day house, I changed the light bulb. That motherfucker was $14.5 million. And now I'm putting a mechanics lien on there. Nothing can live a mechanics lien but you. And they can't stop you from putting it on there. Everything I do in my house for a year, cutting the grass, everything, right? Because they say you're responsible for that. So they need to pay you for that. That's miscellaneous things that should really be coming out of your escrow account. Right? And that mechanics lien, will immediately stop a foreclosure. That's even with your vehicles. See, I'm a little different because back then, when I first learned about mechanics lien, before I learned about discharging, and I would get a car from a dealership, I knew all the real mechanics. And I'm like, put a lien on my car. Put a mechanics lien on my shit. Because guess what? The bank can't even take it if it's a mechanics lien on there. And after so many days, they give the mechanic your title. And I used to pay them to give me my title back. Put a mechanics lien on here. After, depending on the state, it could be 31 days or 61 days that it has to be on there. And then that mechanic can legally go to the DMV and say, I'm pulling the title because of the mechanics lien. They're going to give it. You can do that for a home. That is like they call it a contractor's lien. It's how they've been telling it to us. Oh, the contractor can put a lien on your house. Yeah, it's called a mechanics lien and anybody can do it. And you ain't got to be no certified nobody. You guys did work. You are taking care of the property. They owe you because they somebody's their property, right? You just the tenant, right? So if you renting a house regular, right? You just got a regular landlord and you fix something in the house. Don't you tell the landlord to take it off the rent or tell the landlord to repay you? We're talking about the same situation since they're saying you're a tenant because of the note, which we'll go over next, that you guys signed, right? So, yeah.
So, as y'all see, we just covered this deed of trust and everything that you agreed to up under here. And it was a whole lot of stuff. But again, by signing below, borrower accepts and agrees to the terms and covenants contained in this security instrument and any rider executed by borrower and recorded with it. And sure enough, the signature there, I just blacked it out. So who really agreed to this? Because it's not them. It's you. And you seeing
But it
that
looks
you
like you
can.
wrote it though.
It does.
Yeah, look like you as the lender wrote this as an agreement to them, right? This is the agreement that you gave to them. And sadly, you the only one that signed it. And then they took your signature off of it and put it somewhere else on all other documents. Because when you give them fiduciary duties and rights, it says in the paperwork, you give them the right to sign documents for you. Every time you get a new contract and you do a new security and you assign them as fiduciary, they go and report it to the IRS, saying that they're your fiduciary. That's why when I say when you revoke their power of attorney, not only do you have to alert the IRS, you have to alert them as well. Because if not, according to the IRS, they're your fiduciary. They're the ones that's supposed to be filing your taxes. And they're doing all of that. You just don't know that you're supposed to be doing it as well. Right? But just like you can hire somebody, you can fire somebody. And then at the end, how many of you guys actually ever paid off of a house? Right? Did they ever release your security interest back, your security instrument back to you? That's your instrument. You're supposed to give it back to the trustee, which is MERS. So y'all remember on the beginning of this call when I said, if you go check your stuff under MERS, it's going to say paid off. Well, you let MERS be the trustee. So as soon as that instrument was paid off, guess who they gave it to? Your trustee. But now when you make yourself your own trustee of your trust, guess who they got to turn all them paperwork over to now? You. This is the importance of why they made MERS the trustee, so they can keep lying to us and hiding everything, because they're acting as fiduciary and you didn't assign trustee duties. And according to the Trust Indenture Act, as long as it is a company that has a minimum of 150,000 worth of assets and are registered on the security exchange, which is who? Them, right? Where your note at? It's on MERS. I will go pull that because that's evidence to show that it has been paid off and when it was paid off. They gave the cancel note back to your trustee. But move yourself in the trustee spot and then request it. And you will see that it's been canceled, duly canceled at that. Duly canceled. Okay. You want me to pull up the
the promissory note?
Yeah.
I really want y'all to pay attention to the promissory note because there's a couple things on there that are going to be very important. And like I said, I'm really about to, if you thought that was a lot, I'm really about to break it down. What's going on here?
I don't want that. Freaking bug.
Okay. So I want to go over this note, like I said, because there's a lot of important things that are on here. And then I'm going to give y'all some laws and some court cases to go along with everything I'm telling you so that you understand what's going on, right? Now, borrowers promise to pay. Let's start with the simple language. In return for a loan that I have received, past tense, received. So you already are supposed to have the money, right? Isn't that what it say? In return for a loan that I have received. When did you ever get that money in your account? Did you ever see it? Did it ever come to you at all? I don't believe it did. So you never even received the money, but you're supposed to receive it because it is a purchase money loan. 16 CFR 433.1.
Well, technically, they did receive it, right? So if you actually get the full accounting of when the money got transferred from your trust account, you will see that the check only got your name on it.
Yep.
That's why if you ask them for a statement of account or a settlement of account, especially with a car, you ask them for a settlement of the account, they're going to send you a check, a canceled check that got just your name on there. That shows that you paid it, which you can actually take that down to the, taxation office or the title office, depending on your state. You can take one of our students, got the statement of account, showed that the car was completely paid off by the check amount. She took her promissory note and the canceled check that they sent her. She took it down to the title office. She walked out with her title because she was able to prove that it was paid for. You know why? Because the only name on the check was hers. But when you assign them as trustee, remember I said you give them the right to sign your signature for you. So they got the check, the original issue discount amount. They got it within 3 days, depending on now mortgage contract, they got it in 3 days. A car contract, they got it in 24 hours. Remember that lucky number 3, right? If you're able to get a statement of account and they actually give it to you, you will see the transfer that said came from the Treasury in your name, but because you allowed the title company, when we're talking about mortgages, to be your middleman, it went to them. And they were technically, at the end of the transaction, you were supposed to walk away with the keys to your house because that was a perk of me giving you a security to make money. You're supposed to walk away with the keys to the house and the check. Guess what? The check was there with your name on it, but you didn't know to ask for it.
Nope.
So then they're going to say after 3 years, you abandon it. And they got to give it to, they go, you abandoned, it's a gift, it's etc. Right? And the title company knows this because they can see it all within their system. When you sit at that title company table and they say, oh, you're supposed to transfer us this money. No, they're supposed to transfer you the money, not them. Okay? All right, go ahead, nephew.
I promise to pay US 422,942 plus interest to the order of the lender. The lender is DHI Mortgage. So it tells you you just promise to pay this amount to the order of the lender. So how else would you do that besides taking this note and writing pay to the order of the mortgage company? It tell you in the first line how to do it. You pay to the order of the lender this note. I will make all payments under this note in the form of cash, check, or money order. I understand that the lender may transfer this note. The lender or anyone who takes this note by transfer and who is entitled to receive payments under this note is called the note holder. Now, again, there is an and here because there is a distinction. The lender or anyone who takes this note by transfer and who is entitled to receive payments, because the note can be transferred to someone and they're not entitled to receive payments. So therefore, they cannot be a note holder under this agreement. And that is an important distinction to understand.
So let's go just a little bit deeper with them now. So now we just did the deed of trust. Let me pull it back up for 1 second and let me show y'all something. Okay. Lender is a limited liability partnership. Y'all don't see no name there, dude. The entire time in the deed of trust, you do not see that lender's name nowhere, do you?
What they say right there. Oh no, borrower. Yeah, lender is DHI.
It's nothing right there. Oh, no. Lender is DHI. Borrower, the trustor under the security agreement. So the borrower is the trustor under the security agreement. And then, but you see how close they put it together? Technically, your name is supposed to go there. Where is he on this one? We didn't have the other form. I'll pull it up, but go ahead because I need to get my charge. My computer about to go. Go ahead.
Okay. Anyone who takes the note by transfer and who is entitled to receive payments is called a note holder, right? So you have to have both. You have to have the note and you have to be entitled to receive payments because you can have one and not the other. Now, borrower's right to prepay. I have the right to make payments of principal at any time before they are due. Payment of principal is known only as a prepayment. When I make a prepayment, I will tell the note holder in writing that I am doing so, right? So again, instructions, giving them instructions as to what you're doing and why you're doing it. You agree to do this. I may make a full presentment or partial. I may make a full prepayment or partial prepayments without paying a prepayment charge. The note holder will use my prepayments to reduce the amount of the principal that I owe under this note. However, the note holder may apply my prepayment to the accrued unpaid interest in the prepayment amount before applying my prepayment to reduce the amount of principal amount of the note. If I make a partial prepayment, there will be no charges in the due date or in the amount of my monthly payment unless the note holder agrees in writing to those changes. Number 5, loan charges. If a law which applies to this loan and which sets maximum loan charges is finally interpreted so that the interest or other loan charges collected or to be collected in connection with this loan exceed the permitted limits, then any such loan charge shall be reduced to the amount necessary to reduce the charge to the permitted limit. So this is what I was talking about earlier when I was talking about the required calculations for like interest and things like that underneath mortgages in truth and lending, and that if any of the amounts that they give you, the percentages don't line up with TILA based on all of the factors, that can cause a discrepancy in the mortgage. Now, basically, what I'm trying to say here, I'm going to slow down for a second. Because I don't want to confuse you here. If you read TILA and all of these laws based on your financial situation, how much money you make, all of that stuff, you would be able to calculate how much your mortgage is supposed to be, if that makes sense, right? You can do all of these calculations yourself. Now, the bank and all of these people, they do their calculations and they hand you part of those calculations, right? And then you look at it and you're like, okay, this looks good. And they'll tell you, like, these are the TILA disclosures. But did you know that you can actually check those numbers and see if they're correct? Because sometimes the amounts that they have for the loan charges are over what is required by TILA. And if it's even 1 cent difference, that can cause a lot of problems. So it's important to understand that. And that's one of the covenants that you agree to in here. Now, borrower's failure to pay is required. If the note holder has not received the full amount of the monthly payment by the end of 15 calendar days after the date it is due, I will pay a late charge to the note holder. The amount of the charge will be 4% of my overdue payment of principal and interest. I will pay this charge promptly, but only once on each late payment. All right, and then
so they basically telling you they owe you 4% every time they don't pay you, due to the fact that they are paying you every time they send you a statement. You really can't hold them accountable to that. But technically, because they did send the notice out or whatever. That's why if you ever call one of these companies and you're trying to do a billing error and you tell them, oh, well, I never received my bill, they can't cut your services off. You have to get the statement, right? So if you say it was lost, I never got it, or whatever, it prolongs because you never got it. You understand what I'm saying?
Yep.
And even when you guys are doing like SCS or whatever, it's due by the due date. So people be like, oh, American Express did a dispute, but they took it back. Well, did you send the next statement out on time? It has a due date. Now we know once it hit the post office, it's considered there because it's going to get scanned. But if they say it's due on the 21st and it gets to them on the 24th, technically you just defaulted. It has to be done every month on those type of bills. And not only does it have to be done every month, it has to be done on time. Payment due date. That is the due date to get it in before you forfeit. Okay. That's why I said you will be into default. That's considered default. Now you just gave them a gift because you didn't turn it in on time. You got to start out the way you go hold out. So if you're going to start SCS and then do and pay to the order or etc., it has to be done on time and every single month. The first time you don't do it, you have now went into default. Or if it's late or etc., it is now considered a default. Okay, so it's not them really defaulting on you. You really defaulted on your own funds that actually belong to you because, as I've said forever, that's a dividend check that you get in the mail every month. But it has to be turned in by a certain time so that they can keep the books correct. Okay.
And then Auntie, if you want to scroll to the next page. Giving of notices. Unless applicable law requires a different method, any notice that must be given under this note will be given by delivering it or by mailing it by first class mail to me at the property address above or at a different address if I give the note holder a notice of a different mailing address. Any notice that must be given under this to the note holder under this note will be given by delivering it or mailing it first class to the note holder at the address in section 3A. Obligations of persons under this note. If more than one person signs this note, each person is fully obligated to keep all of the promises made in this note, including the promise to pay the full amount owed. Any person who is a guarantor, surety, or endorser of this note is also obligated to do these things. Any person who takes over these obligations, including the obligations of a guarantor, surety, or an endorser of this note, is also obligated to keep all of the promises made in this note. The note holder may enforce its rights under this note against each person individually or against all of us together. This means that any one of us may be required to pay the amounts owed under this note. So that's, again, pretty self-explanatory.
And that includes
Waivers.
everybody that they sold your note to. Because according to the law,
Indeed.
it says the debtor has the right to assert their rights on any and everybody that's holding the contract. So not only can you make them have to pay you, anybody that is now holding your note is also responsible. Because once they transfer the note and sell the note, they also have a copy of it, right? Because that's how they were able to trade it. So you can hold all of these companies liable because they are in possession of your note as a note holder.
Indeed. Now, this is what I wanted y'all to see. Because remember, you had uniform covenants and then you had non-uniform covenants. Now, this note is a uniform instrument with limited variations in some jurisdictions. In addition to the protections given to the note holder under this note, a mortgage, deed of trust, or security deed, the security instrument dated the same date at this note, protects the note holder from possible losses which might result if I do not keep my promises which I make in this note. The security instrument describes how and under what conditions I may be required to make immediate payment in full of all amounts I know under this note. Some of the conditions are described as follows: if any or all part of the property or interest in the property is sold or transferred, or if borrower is not a natural person, and beneficial interest in borrower is sold or transferred without the lender's prior written consent, the lender may be required to immediate prepayment. And we read all of that in the deed of trust. That's basically giving the same covenant and agreement that was in the deed of trust, referring to the same thing. But now, Auntie, if you scroll down here, this is the parts that I really want y'all to focus on right here. This one right here. So as you can see, right now, this note has been endorsed by the mortgage company to US Bank, right? Pay attention to this. So you are supposed to pay to the order of DHI Mortgage Company, but DHI Mortgage Company just paid to the order of US Bank National Association. Okay? You know what that means? They just sold the loan to US Bank. They sold the loan, paid to the order of. They sold it to US Bank, right? Now, Auntie, if you scroll down again, this is what you guys need to pay attention to. In this transaction, US Bank is the trustee, okay? US Bank is the trustee. Now, US Bank has endorsed this note, but you have to notice there's no payee named on this line here.
That's when
Now,
they can
that is
keep
also
selling it.
important because now this note has, so now DHI Mortgage Company sold the note to US Bank. US Bank has now endorsed it in blank, which means that it can't be assigned to anybody. Right
It's a
now,
bearer security.
yes, but
It's a bearer security. I ain't got no
So
name.
let me get this. Let me get into this, right? Because now that you understand the deed and how the deed and the note are supposed to stay together, you're going to understand why when they break this chain of title, they fuck themselves and every mortgage is unenforceable because they're all done like this. The mortgage company sells it to the trustee. The trustee endorses it in blank, right? They don't name a payee. So now what they do is US Bank acting as the trustee, they sell it to the trust. In this case, it's a Ginnie Mae trust, right? So they sold this debt into the trust. Now, when they did that, in order for the trust to be able to collect the money, they would have also had to transfer the deed, correct? Not only that, they would have to record it. So there needs to be a recording in the recorder of deeds office showing that the deed of trust went to US Bank. And then US Bank would have to then record that they transferred it to the trust. Because under the Consumer Credit Protection Act, 15 United States Code 1641, any transfer has to be recorded, right? Because notice of new creditor, in addition to other disclosures required by this subchapter, not later than 30 days after the date on which a mortgage loan is sold or otherwise transferred or assigned to a third party, that the creditor is the new owner or assignee of the debt and shall notify the borrower in writing of such transfer. So where was the recording of this? Because they transferred the note, didn't they? Twice, it looks like. First, the mortgage company transferred it to US Bank as the trustee. Then US Bank as the trustee transferred it into another trust. Both of these things would have had to have been recorded in order for this to be a legitimate transfer, right? But it wasn't ever done. So that's the first issue. That's the first issue, right? Now, with the mortgage company selling only the debt and not actually transferring the deed, now the note is no longer eligible for negotiation at all because it's less than its full value. Because the full value of the note comes from being paired with the deed together as a security instrument. Once they're broken, then the note is now worth less than its full value. And that means that it can't be transferred. So now, these laws are going to be the same throughout all the states. This is coming from the Uniform Commercial Code. I'm going to read the Colorado state specific ones because this is a Colorado mortgage. But you're going to find, if you take the title of these, you're going to find them in your state. So I'm also going to give you the site so you can look up the laws that I'm seeing. Colorado Revised Statute 4-3-203. Transfer of instruments, rights acquired by transfer, right? If a transferor purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this article and only has the rights of a partial assignee. That's what's going on here. Because one, the value of this note has just been undermined when they separated it from the deed, because both of them together secure the mortgage. One by itself without the other is completely useless, right? So, because they are acting, now also look up this one, Colorado Revised Statute 4-7-501. This is form of negotiation and requirements of due negotiation. The following rules apply to a negotiable tangible document of title, which is what we're talking about here, the note in the deed, right? If the document's original terms run to the order of a named person, the document is negotiated and delivered by the named person's endorsement and delivery. So they would have to, the mortgage company would have had to endorse the note and deliver the deed to US Bank. And then US Bank, they would have to record that. Then US Bank would have to sit there and transfer it to the trust with the deed again in order for them to be doing that, right? Because what's happening now is when you are sending your money back, DHI Mortgage Company is sending that money through US Bank, who's sending that money through the trust to pay back their investors. But the problem is that you cannot do that if the instrument is endorsed in blank. So I'm going to give you two more codes. This is Colorado Revised Statute 4-3-205. Special endorsement, blank endorsement, anomalous endorsement. So like I said, you'll find all of these under the UCC, and also there will be similar variations in your state code. Now, if an endorsement is made by the holder of the instrument and it is not a special endorsement, it is a blank endorsement. When endorsed in blank, an instrument becomes payable to bearer and may be negotiated by transfer of possession alone until specially endorsed, which is why when they have it endorsed in blank, as Auntie said, it's a bearer instrument that they're trying to transfer. Now, Colorado Revised Statute 43203, transfer of an instrument, rights acquired by transfer. If an instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving a receiving delivery for the right to enforce the instrument. So because the freaking lien is unperfected, the instrument is going to an unnamed payee, then no one can even claim the rights to be able to enforce the note. You see what I'm saying? Because US National Bank, they sold away the rights to whoever, but it is an incomplete instrument. And the reason why is, again, I'm going to give you the definition. This is, again, Colorado Revised Statute 43115. An incomplete instrument means a signed writing, whether or not issued by the signer, the contents which show at the time of signing that it is incomplete, but that the signer intended it to be complete by the addition of words or numbers. And then Colorado Revised Statute 4-3110, identification of a person to whom an instrument is payable. So the person to whom an instrument is initially payable is determined by the intent of the person, whether or not authorized signing as or in the name of on the behalf of the issuer of the instrument. The instrument is payable to the person intended by the signer, even if that person is identified in the instrument by a name other than the identification that is not of the intended person. So because it was endorsed in blank, it's incomplete. And so that goes into how the negotiation is not able to happen and the transfer is invalid, right? And there's a couple more statutes where, again, the transfer of a right by instrument, it has to have the intentions. But when it comes to the form of negotiation, this is the last code that I want you to write down, and then I'm going to wrap up this little section of this rant I'm going on. Colorado Revised Statute 4-7-501, form of negotiation and requirements of new negotiation. The following rules apply to a negotiable tangible document of title. If the document's original terms run to the order of a named person, the document is negotiated by the named person's endorsement and delivery. So until a payee is named, technically, no one else can really claim to have rights to gather payment. And this is why when the chain of title is shattered, that's what happens. So, and basically, in order to wrap all of this up, is none of these transfers are proper. They're not recorded properly. This is also why the original trustee remains the trustee no matter how long it is, because until that instrument has a named payee on there and it's endorsed in blank, it's a bearer instrument. And they're able to trade it and do what they do. So I hope y'all understand now why what they're doing is wrong. because I just broke down to you how they're supposed to be recording these transfers, and you can see that they transferred it, they sold it, they wrote pay to the order of US Bank, and then US Bank endorsed it in blank, nullifying the instrument, making it a bearer instrument. Just like that. Now, I also want to give you a court case that talks about this. It is Roger Haas versus Leo H. Fabicher. It is cited at 578 SW 2D 454 1979. And basically, the plaintiff complains that he was entitled to recover on a bearer instrument signed by the defendant. But because the paper in question was unenforceable on its face, they affirmed that he was not able to collect. Now, it's the same thing with all of your mortgage instruments, right? Because what happens is they're trying to claim that because they have a bearer instrument that they're holding, they're able to collect payments from you. But that simply isn't the case, because when they separated the loan from the deed and the mortgage, they lost the right to be able to collect it in the first place. So I hope that makes sense. Because that's how they do you. And you can see it on the promissory note. So you see how they endorse it. Why would you endorse it any differently? Pay to the order of, just like that, without recourse. I mean, you could literally, Auntie, could you go back to that step real quick? The endorsement. Look at that. Pay to the order of, without recourse, by, just like that. That's how they endorse. And if they want you to pay to the order of them, this is how you do it, right? Just like that. And then that's all I really had to say, Auntie. So I see you were pulling up the currency and stuff like that. But yeah, I hope that made sense, y'all, because that's what's going on with your mortgages. This is why they're unenforceable. Every single one. Use that information to your advantage. Prove to them what they did.
Sure can. If you get you can do a title search. The title search to show you that it wasn't perfected, because the only thing they did was they took the note and they uploaded the note. So that's how they had got the initial lien per se, right? Because they uploaded the note electronically to the deed office. The reason why it's not perfected is because they had to come back and show that it was perfected. But they can't show that it's perfected. As Caleb said, the note went one way, the deed of trust went somewhere else, and they have to stay together like Siamese twins. It's going to show that they went separate ways, right? And so it makes it unenforceable. But if you don't never know this, then they gonna do whatever you allow them to do, because you don't know. Okay, so nobody has a perfected lien on your house. Absolutely
No one.
nobody.
It doesn't exist.
It don't exist at all. And the only thing that the deed office got is your deed. And you read the deed. It makes it look like they the borrower, you the lender. You the lender, they the borrower. That's all they had, right? But you never accepted the deed. The title company told you they was gonna do it for you. Oh, we're gonna file these for you. Give me that. I signed. I filed it, right? So you once again abandoned because you didn't know what the next step was, because they sold you with the American dream. And I got keys to my house, and now I'm gonna be debt for 30 years. Yeah, more. Buying a house the way they want you to do is a death sentence. That's why it's called mortgage, mortician, right? So earlier today, we were talking about, it said you had to pay them in currency. Okay. So currency, for all we knew, was this little money or whatever. But as you guys see, it says a currency is a standardized of money in any form in use or circulation as a medium of exchange. For example, banknotes and coins. Banknotes and coins is one, but let me show y'all where it talks about promissory notes. So if you look at standardized money, money is a verifiable record that is generally accepted as payment for goods and services and repayment of debts such as taxes, all that good stuff, right? A banknote. So it said banknote, correct? Ain't that what it said? That's considered a currency. Well, a banknote is called a bill, paper money. So why is a bill and paper money two separate things? And what is they saying that we build you every month, right? Even though it's a statement. Or simply a note. Look like we just got done reading a note. Is a type of negotiable promissory note. Well, it's negotiable because it doesn't say non-negotiable on there, and you see they're able to transfer in between each other. So that made it negotiable. Made by a bank. They are the ones that made the note. They have to make the note because certain things have to be contained in it. Even though the note is yours, they created the note for you to sign off on it. Payable to the bearer on demand. Y'all just seeing here that this is payable on demand. So whoever they send this to can just put their name in there, right? And they can send it off. And then they can send it to the next person and the next person. And then they put their name payable in there. And as y'all see, there's a lawful signature because only a living person can do this. So that's why this is the representative for U.S. Bank National Association, right? But you are the representative for your estate, your all caps name, the straw man, as y'all want to call it. You're the agent for that, just like she's the agent for that, which means you have the right to do this. So when we get into what a medium of exchange is, a medium of exchange is an intermediary instrument. See, when you understand the terminology now, you know what an instrument is, or a system used to facilitate the purchase of sales of goods and services between parties. But for the system to function as a medium of exchange, it must represent a standard of value. Well, the value was the instrument, the value that you're supposed to get, and in turn would be your interest and your principal due over the 30-year term that you are allowing that bank to make funds off of your instrument. All parties to the transaction must accept that standard. You signed it, right? You're saying that you accept it, okay? A medium of exchange is a portable instrument that is used as an intermediary to facilitate the sale and purchase of goods between parties. In modern economics, the medium of exchange is currency. So when they keep talking about we need U.S. currency, yeah, medium of exchange, right? It must remain reasonably stable in value in order for it to work as an intermediary. If the value becomes unstable, it is no longer viable as a means of exchange. But this is where I wanted to get to. A medium exchange, a traditional barter system, only works when both parties to the transaction have something that the other party wants. So what do you want? You want the house. What do they want? They want the instrument. It's considered a barter, which is why they have what's the 99 barter for. They file, but you supposed to file too. A barter is an act of trading goods or services between two or more parties without the use of money or a monetary medium, such as a credit card, or as we know, a security. Okay. This thing opening up everything for what I want. What am I on? Bing or something? The IRS considers bartering to be a form of income that incurs taxes. So remember how I told you guys that when you get audited from the taxes, it has nothing to do with your job, especially if you bought a lot of stuff, car, house, this, that, and they kept going into your account. The IRS triggers it because they like, wait a minute, we see that you did a barter with XYZ company, but you didn't claim it on your taxes, right? But if they're taking money out of your estate, then what kind of taxes should you be doing? That's the question. They're taking from your estate, which is why I've been saying for shit, I don't know how many years to get an estate EIN. You're the agent over the straw man, right? You're the agent over that estate. So that estate is its own separate entity. So you have to operate it like this is its own separate entity, right? And that's why all your jobs is like, that's why it's compensation when it comes to a job, because you bartered services. They can't pay you money. Did they give you a medium of exchange? No, right? That's no different than me hiring a contractor to come and do a job. That's what your job is doing. Because they sure got y'all down as a fucking contractor, right? So everything is a barter. Y'all are trading goods. You want this promissory note, I want this house. You want the security, I want this car. And because you're not filing properly, they're now making you responsible for all the taxes, which is ultimately why people get audited or etc. Or when you work a job and they ain't paid the taxes, you ain't paid the taxes, and you're like, oh, I didn't pay no taxes this year. Nah, oh no, they didn't pay the taxes. It has nothing to do with you. But because you never reported that you did a barter of services between them and them, they reported it. They put down that you got something from them, right? But you never put down that you gave them something. And so that's how you end up being stuck with taxes, because you didn't file properly, right? So that's just the long and the short of that. It's a medium of
Yep.
exchange. So now y'all know what currency truly means. So when you're talking to these people, I've said it before on a live, when it comes to you guys trying to get things overturned, and what did I say? Tell these people, we did a straight up barter transaction and you are not upholding your end of the barter transaction. And I'm telling on you. I'm telling the IRS that we bartered and you renege it because you're not doing what you're supposed to do. But honestly, are they? Or are you not doing what you're supposed to do? Right? You give these people an application, they give you a no. Do y'all know that when they send you a denial letter, that is an offer? You got 30 days. Some of them will tell you, oh, you got 60 days to appeal this or something if y'all read the letter. So in my return, oh, you're going to deny me? Okay, no problem. I'm going to get this denial letter. I'm going to write on there denial denied. And I gave you, this is in a medium of exchange. I'm not giving you any gifts. This is a barter transaction. You get paid, I get paid, everybody's happy. And that's how you guys have to come at them. But you got to use the proper terminology. So now you know what currency means. Now you know that y'all are doing barter transactions. Now you know that your house don't have a perfected lien on it. So technically, the only thing that's holding you to that house is because you signed over rights for them to sell, for them to foreclose, the same way in your car contracts, right? You gave them the right to repossess. You gave them the right to keep all your money from all of your insurances and all of this extra shit, right? But if they're not doing their job properly, you have the right to go back and change that. So if anybody going through anything when it comes to your house right now, you need to immediately switch over who has the rights to your property, who has to say so, who can say it can be sold. Right now they can change it so you can say you can. Can't nobody sell this mug but me, but my trust, and I operate the trust. I own nothing, control everything. Right? Putting it over into your trust, because a trust deal with a trust. Well, if we know that they're depositing our stuff within their trust, if you got a trust, it's in the trust name, it's staying within the banking system, the PO box, right? Bank against bank, trust against trust. It automatically settles it out. immediately it settles it out. Okay. So that's the breakdown of the contract when it's so you guys can see what you actually agreed to. And because now you know what you agreed to, it's going to be easier to change those terms and get it re-recorded properly, doing an acceptance of the deed. But we all know these people like to play games. They like to act like you ain't sent nothing, you ain't did nothing. But see, this has to be recorded down at the county, because the only way that they can foreclose on you is by going through what? The county. But if it's registered that you have accepted the deed, you switched it over to a trust, I still tell people put a list pendants on it, put a quiet title on there, hell, put a mechanics lien on there, right? That way they can't, because see, as long as they're still trustee, they can deny you. You gave them the powers to do your work for you. Ain't nothing coming off no mechanics lien, because they need the natural person to come down there and either pay them or take it off. And I will personally, if I put a mechanics lien on my house, it would be for whatever the amount of my mortgage. That is what the mechanics lien would be for. Okay, bank, you want this house? You're going to pay them this mechanics lien. Now your house is in your trust name. They don't know that Shantae is the one that put the damn lien on there, because this ain't Shantae name on there. But the house is in the trust name. So you as a national bank, you're going to pay Shantae $450 million first before you can take over this house. It's not going to be worth it to them. And the county will not let them sell it, because a mechanic lien trumps everything. You're already past the point of putting the foreclosure exemption on there. If you guys were to do it now, it will not take effect until next year. You have to file that by April 1st of every year for it to take effect for the year that you're in. So if it's done now, it won't take effect in 2025. But they've already filed it, right? So everything that they filed actually travels with the home. So after you switch everything over and you had a copy of that, I would amend that to the foreclosure exemption, because now you're now the beneficiary, right? And they already put themselves in the borrower box. Their name is in, I'm telling you, is in the borrower box. Then beneficiary, they got merged. Well, because you changed the beneficiary to you, now that exemption that they had got already for you, thank you, doing your little job, I just switched it all up and took your name off. Now I got the foreclosure protection as well. And the county cannot let a sale go on while you're in this process of getting your property, your land, your coordinates. Because we'll get into that tomorrow on Sunday, how to properly redo your deed and how you have to transfer the exact verbiage and language. And if you notice, it's going to give you coordinates, lot numbers, this, that, and the other. Why? Because everything is numerology. Banks cannot own property. Nothing said about they can't own land. Banks cannot own property. It is actually the land. If you notice, it has the land coordinates first, then it'll say as known as, then it'll say property address. But what is property? Property is only in a military jurisdiction because they broke everything up by zip codes, and zip codes are under military jurisdiction because it's all tied in together. Okay. We'll go over the RESPA and what that is, especially for people who did not have the 3-day clause in your mortgages. That means that they didn't even give you full disclosure that you had 3 days to cancel. The thing about the 3-day rule, though, is you got 3 years to say something about it. Here we go with them threes again, right? So then you will have to sue them a different type of way. But to save people homes, everybody need to transfer their homes into their proper property, put it inside of a trust the way that over to the trust. And you will quit claim deed it to a trust using lawful funds. Right? If you already got a UCC one filed and you got silver certificates, or if you got any of the coins that were certified and they got barcodes and things on there, you guys are supposed to register that on your UCC, the serial number, and you can take a picture of it and you can upload it, right? I sold my house for 10 coins. You can get 10 silver coins right? Go get the 50, the half a dollars and say you sold it for that. Why? Because anything that say 99% silver, United, that's real coins, right? That's real funds. Y'all seen it for yourself under the medium exchange. It said coin, right? Because nobody else that's trying to stake claim over the property can outdo lawful funds. So your silver certificates that you guys got, you have to register on your UCC one if you have a UCC one filed against your estate. Anything that you acquire regarding that, it needs to be added in there. Okay. When you take over the property, you add that in there, the title number, the lot number, and etc. Okay. So we went over that. Sunday we'll go over the steps that need to be taken, what documents you guys will need to have, and the order that it needs to be done in so that everyone is successful at transferring their home. Trust and believe me, there are a lot of these counties that, why are you doing that? Some of them have no fucking clue, but you have the right, just like you can go down there and do a quick claim deed, which you are going to do. You're going to do a quick claim deed over to your trust. Absolutely, you will. But you got to accept the original deed, right? So you got to accept the original deed. And then when you move it over to the trust, you need to do an acceptance of that deed up under your trust name, with you being a representative. So we'll go over those things as far as RESPA and the forms that is needed for you to take back control of your home the proper way. And then after you do that, that's when you go back and you file the proper taxes to alert the IRS that you did a barter exchange with them, and they need to pay their taxes because they're not paying them. Even if you ain't got the CUSIP number, even if you don't have anything, they will go and investigate it and get it, but you have to know how to properly be able to do that. Okay? So on that note, you guys have a very good night. I will see you guys on Sunday. If you've already registered, all you got to do is just wait for because I am going to change the password. But it's the same link for you to be able to get in, just a different password. I will see you guys Sunday at 7 o'clock. I am on a break from social media because I am preparing myself so I can be like a go Power Ranger on the A-Frame. I can get my superpower. So I am in protection of my energy on another level. They blocked me earlier, but I haven't even checked to see if I can repost, so I will not be on there. But I will see you guys on Sunday. Or whatever, you guys enjoy your Saturday and read your note, highlight some things. If there are some things in your note, I'm going to also show an older type deed, warranty deed. Because for some reason, the new ones, they not putting that warranty deed in there, but I will have one up to show you guys, because that warranty deed shows that you had the property all 100,000%. It should be in every last one of y'all packets, the warranty deed, but you're definitely going to need that. I will go over that on Sunday as well, so you'll know how to properly accept the warranty deed, because that warranty deed said that the land was yours forever. That warranty deed says that the bank sold you the house for $10. Anybody that got that paper, and it may not be called a warranty deed in your state, but look for the document that say that your house was either $10 or $1, because you're going to need that when it's time to go down to the county, because you never accepted that, right? You owned the house for 2.2 seconds, because as soon as you signed the note, it was a wrap. Like, people don't know, if you in here and you in the process of buying a house, if you only sign that one sheet of paper where the bank transferred it to you, where it said it's your land forever, grab them keys real quick, and you don't sign the note, they don't have anything, because it's the note that's tying you to them. The warranty deed gave you a warranty that there was no liens on that property, that it was free and clear, and that it was yours forever, and that it was $10. This is how the banks are getting away from not paying taxes, because it looked like they only made $10 on that transaction, or $1 on that transaction, right? But because they got this note, with these high numbers on there that they swore they sold you a house for, it's making you believe, which is false and misleading, that you owe them this amount. No, that is them saying, hey, if you give me this security, if you bought a house for 350,000 and then with interest it came up to 772,000, by you giving us this note, we promise to give you back 772,000 in regular periodic payments, which is what they're doing every month. You just don't know how to get them from them, all right? Because you think that you owe it. So you guys enjoy the rest of your Friday. It is Friday. Yeah. You guys enjoy the rest of your Friday. I will see you guys on Sunday. Read over your note. If there are some parts in there that you don't understand that we did not cover, highlight them. I'm thinking possibly we'll do a small Q&A after the last class. But highlight them so that you can understand more. And now y'all know what currency is. Medium of exchange, right? Medium of exchange. So on that note, you guys have a very wonderful evening, and I'll see y'all on Sunday.
Bye-bye.
Bye-bye.